Hi guys, so in today's video, we are going to talk about void and voidable contracts. So just to give you a roadmap as to what all we're going to discuss today, as you can see, we are going to talk about the Indian Contract Act of 1872. We will also see what is a contract. We'll also deal with the classification of contracts. And lastly, we'll also touch upon the remedies in case of void and voidable contracts. So let us start with the relevant piece of legislation. As you can see, the relevant piece of legislation when we talk about contracts in India, it is the Indian Contract Act of 1872. Now, as you can see, it is passed in the year 1872, owing to which it is a colonial piece of legislation. So the Indian Contract Act, as it stands today, can be broadly divided into two parts. So the first part is the part which deals with the general principles of contracts. So all the contracts in India, unless the parties decide otherwise, would apply these principles when they talk about contracts. Whereas the sections 124 to 238 deal with certain specific kind of contracts, such as bailment, pledge, agency. Now, if you notice from sections 76 to sections 123, there's a void, right? There are no sections 76 to 123 on your screen right now. The reason why they don't exist right now is because earlier Indian Contract Act also used to deal with Sale of Goods Act, which is now, it used to basically deal with sale of goods. Now it is a separate piece of legislation which is known as Sale of Goods Act of 1930. Now, since it's a separate piece of legislation, all those sections which were earlier a part of Indian Contract Act have been repealed and reproduced in that particular piece of legislation. So let us move ahead and check out what a contract is. So this is a very simple definition put in layman's term. It is an agreement which is enforceable by law. Now, obviously, this is not an entire definition. It's just for a simple understanding of what a contract is. So when we talk about an agreement, to simply put, it's an offer which has been accepted. So when two or more people are agreeing on the same thing in the same sense, they are said to be in agreement. And when you see the second factor, which is the legal enforceability factor, so that is basically when one person does not do or refuses to do what was agreed, other person can go to court and force him to do so. So basically, you can get your contracts enforced in the courts. That is the second factor. Now, let us just briefly deal with the essentials of a contract. So as you can see, a contract is supposed to have a lawful object. So you might be having all other essentials, but if your object or the subject matter of your contract itself is unlawful, your contract won't be a valid contract. Competency of the parties is yet another factor. Just to deal with it briefly, you can say that the parties which are involved in the contract have to be competent enough to get into that contract. So to give you an example, a minor or a person with unsound mind are not competent enough to enter a contract. They are incompetent parties, owing to which if one of these are said to be parties to a contract, that contract won't be said to be a valid contract. Similarly, lawful consideration is another factor. The consideration which is involved has to be lawful. It cannot be unlawful. If that is the case, your contract will not be a valid contract. And not expressly void. So obviously, if there is a law in your country which tells you that so and so thing is void, for instance, gambling may be valid in some place, but if in your country your government has said that gambling is going to be illegal, thus, if you go ahead and create a contract with such subject matter which is already expressly void, your contract is ipso facto going to be void. And this last factor, free consent. This is one of the most important factors which has to be present in your contract for it to be a valid contract. Now, all of these essentials, you can also refer to section 10 of the Indian Contract Act to get a better overview of the essentials of a contract. Now, let us just see the classification of contracts. So there are two ways you can classify contracts. First is the validity aspect, and the second is the formation aspect. So when we talk about formation, Your contract can be express contract, it can either be implied, or it can also be a quasi contract, which is also known as fictional contract. When we talk about validity, it can be a valid contract, it can also be an illegal agreement, or it could be a void and voidable contract, void or voidable contract. So these are the two concepts which we would be focusing upon today, and that is why they are highlighted. So let us deal with void and voidable contracts. So the sections which deal with void contract and voidable contracts are sections 2J and sections 2I respectively. The definition you can refer to these for the definition you can definitely refer to these sections, but what you can see on the screen right now is a simple meaning of what a void contract is. So to simply put, it's a contract which was previously valid, but now it has ceased to be enforceable by law. That is your void contract. And when you talk about voidable contracts, it is a contract in which one of the two parties has the option to either enforce it or to rescind it, which basically means you can either cancel the contract or you can go ahead and continue with it. Now, obviously, the only party which can do this is the one which has been wronged. So that party is known as the aggrieved party. When we talk about void contracts, often we also confuse it with void agreements. These terms are sometimes used interchangeably, which is not correct. When we talk about void agreements, these are dealt with in the Indian Contract Act specifically. For instance, the agreements with respect to unlawful consideration, or the agreements which are in restraint of marriage or which are in restraint of trade. These are void agreements, whereas void contracts are something which was previously valid once, but now owing to different factors it has become void. So let us deal with void contract a little more in detail. So as you can see, it is enforceable in the beginning, but subsequently it lacks enforceability due to either a change in government policy, or it could also be that the particular activity has become impossible or illegal. So let us take an example. So for instance, if there is a dancer and there is a company, and you as a dancer have contracted to a company that you are going to perform a concert. You have also taken an advance of 5,000 rupees, and the remaining 20,000 you have said that I am going to take my remaining payment once the concert has been performed by me. Now, before this, you meet with an accident, owing to which you have been injured so badly, your legs have been injured so badly that you cannot dance anymore. Okay, now this concert cannot take place because the doctor has told you that you cannot dance. You have injured your legs so badly. Now, because this act has become impossible, this contract has also become void. Now, why is that? Because so when we talked about void agreements, those were the agreements which were already void from the beginning. But if we see the example we just talked about, it was a valid contract once upon a time. But owing to the impossibility, now it has become void because it cannot be enforced in court anymore. So you may ask, what is the remedy in case of void contracts? Sorry. So when, as you can see, the void contracts cannot be enforced in courts. However, if any benefits were taken, they need to be restored. So in our example, let us get back to the example. Let us talk about the 5,000 rupees which you have taken as the dancer, as an advance for your performance. Now, obviously, the performance did not take place. So this is a benefit you have taken out of a void contract. And this is something which you need to give back to the company. If you don't do so, the company has the remedy to go into the courts and get this entire thing restored. So that is about void contracts. And for the voidable contracts, we will end at this. We'll end at voidable contracts, which are the voidability as a factor is dealt in sections 19 and 19A. And this is the part wherein free consent, as I told you, free consent is a very important factor. So this is the part wherein it comes into picture. So if you have a contract which was basically gone into without free consent, maybe you were coerced into going into a contract, maybe there was undue influence, or you were misrepresented certain facts, or maybe the other person simply committed fraud for you to enter into a particular contract. When all of this takes place, maybe the other essentials are there, everything is fulfilled, but because there was no free consent, you as a person has the right to go in court. So maybe at this particular point when you were coerced, you did not have the power to not get into the contract. But the courts have given you a remedy that once everything is restored, once everything is normal, you can go to the courts and you can say that, you know what, this was done by an act of coercion, and that is why I want to cancel the contract. But at the same time, you also have the option to continue with this contract. So as to say that maybe you entered into the contract because of coercion, but after a point you thought, you know what, it's not actually a bad contract, I can, go ahead with it. So at that point, if you feel that you want to continue with the contract, you can also do so. So that is why the remedy when we talk about voidable contracts is either you can basically, you the aggrieved party, either you can rescind the contract, which is basically canceling the contract, or you can enforce the contract as well. So that was it about void and voidable contracts, and we would deal with other concepts in the upcoming videos. Thank you.